So, Mr. Chair, you do have a quorum physically present.
Thank you. So the meeting is now called to order. So everybody, all of the members of our committee, would you please turn off your cell phones and put them away in such a manner that they're not, won't be a distraction. Thank you. Everyone has the agenda packet, so we're good to go. I will call roll. So Marcus Crowley, here present. Jeff Canberra,
Present.
good. Yusuf Herbert,
Here.
okay. Yusuf Herbert, you request to join our meeting via Zoom.
Yes, I already discussed this with Mark.
And you're aware that in order to participate, and according to the Brown Act, you must have video and audio, correct?
Yes. So, Mr. Herbert, if you could turn your camera on, we would.
Oh, sure. Let me adjust it. 1 second. Thank you.
Oh, Mr. Herbert, are you requesting to not be here in person?
Yes, we've already discussed this. We can move on to the next roll call, please.
Okay. Yes, Mr. Herbert, what is your reasoning for
We could discuss this later, and we can move on to we have a full agenda. We've already discussed this. It's already been stated at the last meeting. We can move on. Will you please call in for the roll call? Can you continue, Marcus?
Herbert is being argumentative? Could you please-
Can you continue on with the roll call, please? And not have the focus always be about myself? Thank you.
Mute you now, Yusuf.
Okay. So
So-
Mark, thank you for muting him. I will ask him a question. He can answer it. Then you can unmute him so he can answer the question. Okay?
Okay.
So, Mr. Herbert, according to the new Brown Act requirements, you must state your reasoning for not being here present. So what is the reasoning for not being present?
No. Yusuf, apparently I can mute you, but I can't unmute you. There you go. All right, now you're good.
All right. No, we could just move on we could discuss it later, Marcus. We can move on to the next, to continue the roll call with the addressing the remaining members here. And we can move on to the next subject of the agenda. That would be great for all of us. Thank you.
If I may, Mr. Herbert had mentioned to me that there's a medical.
Yes, and I didn't want to really make it that attention to everybody openly tonight. That is something I feel that I could discuss. If anybody has a question about that one-on-one, we can discuss that. However, I did not feel the need to really address everybody about that tonight. But that will be solidified and clarified when the attorney has a chance to speak in a matter of minutes as well, too. So thank you. Can we continue on at this time also? Sounds great.
Mark, would you please mute him so I can
Continue.
question? Thank you. Is Mr. Herbert stating a medical emergency?
Not an emergency, but a medical situation that prevents him from attending in person.
The Brown Act requires a medical emergency.
I don't think that's the case. He let us know in advance by providing his physical location.
No, that's a different a different requirement. So on the government code, section 54-953, section F A2 says a member requests the legislative body to allow them to participate in the meeting due to emergency circumstances. So what is the emergency circumstances?
So he provided his address in advance, so it's not an emergency exception. He provided his physical address in advance, indicating that he would be contacting us remotely. So it's not an emergency situation.
So then it must be then just cause, is that correct? There's only two requirements, one or the other. For remote attendance, it must be just cause or medical emergency. So, which is it?
He said it's a medical situation, it would be just cause.
This second adder is just cause. Has Mr. Herbert stated the reason is just cause? Mark?
The reason is a medical situation. We have to be very careful about discussing medical situations in a public environment. This is a public forum. So I think that's why he's reluctant to discuss things openly. It's a medical situation.
So when did the medical situation occur? Mr. Herbert, when did the medical situation occur?
Yusef, you need to turn your microphone on again. I'm sorry.
I'm not liberty to discuss this. I was just saying Andrea has had her hand raised. If you wouldn't mind calling on her, she has a question and we can recognize her and we can continue on. Are we finished with the roll call at this time?
Mark?
I'm confused.
He's not answering the question. And section 6 here says that the member shall make the request to participate as soon as possible when the event occurred.
That occurred. Mark had my address. I'm here. I'm present. We can move on. All the requirements have been met.
Thank you, Mark. So we don't know when he requested to remote attendance.
We could just say it was last year. We'll say it was last year. Now we can move on to Andrea's question on the.
Mark? Yeah. Okay, so he's muted now.
He is muted.
Okay, so the Brown Act requires that he request remote attendance as soon as possible after the pursuant to this clause, as soon as possible, or when the emergency happened. Now, I presume that that means that he either contacted the chairperson with the emergency or the just cause, or he contacted you. And so we need to know when the emergency happened so that we know as soon as possible.
It was done. Mark has noticed. He had my address. We already taken care of all this. Again, have we even completed the roll call? Andrea has had her hand up for the past 5 minutes. Will you please call on her to recognize her as a committee member who has a question to put forward to committee?
Okay, Mark, he's being argumentative, so
you could call me what you want, The point is, we're here to discuss matters of hand outside of my attendance, and we need to move on.
Thank you, Mark. So now the next step is the members of this committee will vote on whether or not Mr. Herbert is attending with proper excuse. So I will take a vote.
Wait, hold up. I wasn't told about no vote regarding me and my proper excuse tonight, or whatever you want to germane it or color it to be. We're here to discuss the Brown Act with the attorney present to discuss this. We're not here to discuss myself and my attendance here tonight, this meeting.
Okay. At the chair's request, I've muted Mr. Herbert.
Mark, yes, I'm going to ask your opinion right now. Okay, so I give you the floor.
Thank you. So, Mr. Chair, I'm very uncomfortable with this line of questioning because Mr. Herbert has told us previously that he has a medical condition that prevents us from attending these meetings in person. It's not an emergency. It's an ongoing health situation. And we should not be discussing an ongoing health situation in a public forum like this. And because he provided notice
Correct.
of his remote attendance in advance, and it was agendized on the agenda, it should not require a vote of the committee.
Well,
Absolutely not.
are you done?
I'm done, yeah.
Okay. Andrea, you have the floor.
So you want to call for a vote right now to have whether he has permission to attend this meeting remotely. So I'll tell you right now, you need to finish the roll call. We need to finish the roll call. You don't even have a quorum in this room until you finish the roll call. We have not been recognized as a body sitting at this table that you have stopped and entered into this discussion of just cause or emergency. So I'd like you to continue the roll call.
Yes.
Okay. Are you done?
Yeah.
Okay. Thank you. Yeah.
So I'm just point of clarification. So I heard you could be remote up to 3 times.
Well, yeah, I think you do. Okay.
Oh, okay.
Jeff,
So is
you don't have
medical-
the floor.
So is medical outside of those 2 times?
I don't know. We happen to have an attorney on the call who can tell us when we get to that point in the agenda.
And I think you're mixing 2 different requirements there. One is the number of times that a person can attend with a video with a just cause or excuse. And that says twice in a fiscal year or an annual year. Actually, it says a calendar year. And what we're talking about is something different. And so this is what is allowable for a person to attend the meeting without a approved reasoning. And so just because a person says, oh, this is medical, that's not a reason. It's the requirement says you have to give some kind of text to so that we understand what the situation. So for example, if he said, I had an accident and my doctor said, well, then we have some kind of understanding. So he doesn't have to say exactly what it is or what he talked about to his doctor. We have to have some kind of basic understanding of what the emergency is or the just cause is. And if that is not there, then the members can and should vote on whether we approve his remote attendance. So, Ben, do you yield the floor?
I'm done.
Okay.
Jeff has a question.
No, so I disagree with your interpretation that medical is sufficient and anything beyond that would invade his privacy in a public forum. So I will object to that line of questioning
Yeah.
and that as a reason to deny him to participate.
Well, I studied this. I studied this in particular because I knew it was coming up. And Mr. Herbert has used this excuse a number of times, just saying, oh, my doctor won't let me. And that is insufficient.
Excuse me, I never said that. I never said that. You have emailed me.
Mark, would you mute him? Thank you. And keep him muted until he has the floor. Mark? Okay. So I think that we have a duty to understand at least the basics of why he is claiming to have the right to participate remotely and now let's see what was going to say. And furthermore, to my knowledge, he never informed us that he was going to be attending remotely.
Mark knew all of this ahead of time. He had all my information. If you were not privy with it, it's irrelevant at this point. We can move on.
Please.
We can move on to the matters of the business, which is discuss sharing surrounding questions as well as being able to hear from the attorney tonight.
Mr. Herbert does not have the floor and does not have the authority to grant somebody.
And if I do leave, there would be not a quorum, so we will not be able to have these meetings at any given time as well too.
Sorry, Mr. Herbert.
Keep that in mind.
Ask me to mute you.
Oh, you want me on? Okay. Sorry.
Sorry.
Go ahead, Mark. We're having our.
Okay. So, yes, you still have the floor.
Good,
So
you can continue.
yeah, so really, we need to have some kind of knowledge. And he has to have an advance notice that says here as soon as possible.
He has gotten that. He has that. We can discuss all this. We can vote on my attendance at the next meeting. Right now, we are here to hear from the attorney and also Sharon Swan. So let's move on to the business at hand at this time.
And you control the screen up there so we don't have interruptions.
Mr. Herbert is muted.
Okay, so, okay.
Sorry, Mr. Herbert, muted at the request of the chair.
I'm sorry, Mark.
The chair has asked me to mute.
Thank you. So, Jeff, have we said everything that we can say about this?
No, I don't think so.
Okay, so tell me more.
So I will go back to any of the other appearances that Mr. Herbert had to make were irrelevant because he was not on video at the time. So regardless of what his excuse was, it didn't count. This is the first time that he has followed the procedures. So I believe satisfaction to be able to participate. The rest of the time, he was just simply an audience.
Yes.
So regardless of what the reason was, it makes no difference. It's irrelevant to tonight's conversation.
Okay. And how do you respond to the clause that says notifying let's say, the member shall make the request to participate remotely at the meeting pursuant to the clause as soon as possible? Please, so please.
Were you notified by Mr. Herbert that he was going to participate remotely.
Yes, sir. And Mr. Herbert's remote address is agendized on the agenda for this meeting.
So unless there's a provision in the Brown Act that says he specifically, we can name specifically say he cannot participate, then he has fulfilled the requirement.
Well, all he did is say that he would not participate in person. He did not.
No, that's not true.
Okay, what?
Can you, without invading Mr. Herbert's privacy, can you disclose what he said to you?
He told me that he has a medical condition that prevents him from attending meetings in person.
So that fulfills the requirement for this evening.
No, it doesn't.
We'll disagree.
It can, and I say, you know, I want your opinion. I just want to give a different twist about that. And that is, did he state whether it is medical emergency or just cause? And when did this occur? And did he let us know as soon as possible? And so those are all requirements. So Mark did not give me those data. So maybe Mark can tell me that and I will be satisfied. Okay?
I disagree that the law is that strict, that as long as Mr. Herbert fulfills the requirements and discloses to the committee, or in this case, to Mark, whether it's an emergency or that it's just cause, that he has fulfilled the requirement. I do not believe that the law requires Mr. Herbert to know the Brown Act in that level of detail to say, Mark, under section so-and-so of the law, I am telling you I cannot attend tonight. He's given a sufficient reason.
Well, I disagree with you on that, but setting that aside, let me ask Mark to relate what happened, okay?
Can I ask one question?
Yeah.
Are you familiar with the concept of substantial compliance with statutory requirements?
Yes, I am. I've heard that term.
Are you familiar with it enough to be able to apply it in this case?
Well, like you asked me many times, am I a lawyer? And I said, no, I'm not a lawyer, but yes, I have studied this provision because I knew it was coming up. So I'm probably as familiar with this as anybody. So did I answer your question?
All right, because if we get it wrong, we violate the Brown Act.
Exactly. And that's what I'm trying to avoid. And I don't want to say, oh, well, that's plenty good enough, and then have it next meeting saying you guys violated the Brown Act, because you're supposed to, you're supposed to understand what his emergency is, when it occurred, and did he notify us as soon as possible. Now, apparently, some kind of a medical emergency occurred many months ago. We don't even know what it was, even the nature of it.
You are out of order. I'm sorry.
I just want to make one comment to that, and that
This is ridiculous. This is absolutely a waste of time. And we need to get on with the matter at hand and the attorney being present. And
So Mark,
we violate the Brown Act by denying him.
he's doing this is all on purpose to just get away from the subject at hand. He's never discussed any.
Sorry, Mr. Herbert, the chair had asked me to keep you muted earlier.
If he's gonna mute me, Mark, I'm about to just,
Please give us a chance, use it for 1 moment. Okay.
Mark, you have the floor.
Thank you. Two comments. First of all, is that we have an item on the agenda about the Brown Act. We have legal counsel on the phone with Mr. John Palmer. If the chair would be willing to acknowledge Mr. John Palmer, we could answer this question with legal authority. Second comment is I'd like to introduce you to Dr. Tamil Gilkerson, our new chancellor of the district.
Hi.
Welcome. Thank you so much.
thank you all for your service. I really appreciate it.
Congratulations.
Thank you so much. I mean,
So we're in the midst of roll call, and at this point, Mr. Crawley is here, Jeff Canberra is here, and we've been discussing Mr. Herbert.
Okay, I'll say, 1 second, Dan, let me say something. I propose that we finish the roll call and allow Mr. Herbert to attend remotely. And then when Mr. Palmer tells us about the Brown Act, he can give us some advice about this thing. And if we are indeed violating the Brown Act one way or another, we can correct it right now. Is that satisfactory with you, Mark?
That sounds great to me.
Okay, so then we will continue with the roll call.
Could I just get the clarification that he's participating as a board member and can vote?
No, as a committee member,
Excuse me, as a committee member and be able to vote?
yes.
Okay, thank you.
Henry, I'm sorry.
So continuing the roll call. Henry Dawson.
Here.
Benjamin Scott.
Here.
Good. Bill Blowhurst.
Here.
Okay. All of the members of this committee are present. So the next item is to approve the agenda meeting agenda. I move that we approve the agenda. Is there a second? Okay. All in favor of approving the agenda, say aye.
Aye.
Opposed? Hearing none, the agenda is approved as it is.
Mr. Herbert, you approve the agenda?
Yes.
Thank you, sir.
The next item is a public comment. Is there any public comment about a non-agenda item? Hearing none,
Sorry, Mr. Crawley.
yes,
I would like to make one public comment.
yes, please do.
So at the last meeting, there was, you made some comments about the origin of this committee. And I just wanted to address this in public for the record. The origins of this committee, it started with one oversight committee that was responsible for both the parcel tax and the bond. And early in 2019, the decision was made to create two different oversight committees, one for parcel tax and one for bond measures. And so the bylaws for that were approved by the Board of Trustees in 2019. And all of the members of the former Citizens Oversight Committee chose to participate in the parcel tax committee, which is why this committee essentially started from scratch. And the former committee was responsible for both voter approved incomes for the district, and the new the new structure separated those, which is great. It's a smart thing to do. There is different laws applied to the different committees. So I just wanted to add that context for the creation of this committee. Thank you.
Thank you. I'd like to respond to that. And my response to that comment is the district had a duty to establish this Citizen Bond Oversight Committee within 60 days of ratifying the election outcome. So what the district did in order to establish the Bond Oversight Committee, it disbanded the Bond Oversight Committee. So that was a method of handling things that was unnecessary and probably illegal, but it's water under the bridge. it is similar to our Vietnam War efforts, where we're going to save the village by destroying it. That's the district was supposed to establish the Oversight Committee, and instead it disestablished the Oversight Committee. So that didn't, so that your explanation is just fine for separating the two, but it separated the two in an illegal manner. So, yeah, if you want to comment one
I do, but I don't think it's appropriate to argue that point. You've stated your opinion.
This is not agenda, not meant to be a discussion.
Right, staff all the comments.
Right.
So we have two comments there. Moving on to agenda item number 4. Approve the minutes from our last meeting. They are attached. Is there, before we do that, is there any public comment about the minutes from our last meeting? Hearing none. Is there a motion to approve the minutes from our last meeting?
I'll make the motion to approve the minutes.
Okay, I hear so moved. Is there a second? Okay, moved in second. Let's vote. Everyone in favor of approving the minutes from our last meeting as they are stated? All say aye.
Aye.
Aye. Okay, opposed? None.
We
The
should check
minutes
these.
from our last meeting is approved.
Mr. Herbert,
Is Mr. Herbert,
He needs to be unmuted the whole time.
I approve.
thank you.
thank you, sir.
Okay,
Can I just make a point of clarification that, Yusef, you can't be muted at all during the meeting. You have to have audio and visual on the whole time, or you technically aren't attending the meeting. So just to let you know, okay? Thank you.
Okay, yeah. I'll try to stay unmuted. If Marcus doesn't.
Thank you.
Well,
So we're now at agenda item number 5, the roles and responsibilities of the Citizens Oversight Committee. Mr. Palmer is going to address this. Mr. Palmer, you have the floor.
Thank you, Mr. Chairman. Would it be helpful for me to present the slide deck on the screen in front of you?
Yes, that would be very helpful. Thank you.
Okay, give me 1 second and I should be able to call it up here. Okay, can everybody see that?
Yes, sir.
Excellent. Okay, and I apologize. It seems like it messed up the formatting a little bit. And the translation to Zoom. So just a little bit about me. I am a partner at Warwick, Harrington, and Sutcliffe. We're headquartered in San Francisco, and we are the oldest bond counsel firm in California. Every year, we are ranked #1 nationally as bond counsel. My particular practice focuses on schools, community colleges, cities, counties, and special districts, primarily in California. A few of my clients include Oakland Unified, San Francisco Unified, Contra Costa Community College District, the counties of Alameda, Santa Clara, and San Mateo and San Francisco, and BART. So I work a lot locally with major issuers, and in my capacity as bond counsel, I work with a lot of oversight committees across the state and locally, many of which I've worked with since inception. So I was hoping that we would be able to talk today a little bit just about the basics of being an oversight committee. and we'll talk a little bit about the Brown Act as well as part of that. So oversight committees were born in 2000 in conjunction with Proposition 39, which lowered the vote threshold for school and community college districts from 2/3 to 55%. The proposition itself came with several accountability measures, including increased specificity in the ballot measure and independent financial and performance audits. During the legislative wrangling that happened after the initiative was proposed, additional accountability requirements and restrictions were placed on school districts as part of a bill that was enacted upon Proposition 39's passage. And among those were the requirement to have an independent citizens oversight committee. As the sort of court that decided the preeminent Proposition 39 case said, the goal with all of these was to make it easier to pass school bonds and to ensure that district boards actually spend the bond proceeds on the projects that the voters approved. And I think that's the sort of the core of why oversight committees exist. I think it's worth adding here that not only are oversight committees intended to ensure the district spend bond proceeds on voter-approved projects, but that they do so efficiently and without waste. So the goal here is to ensure that district boards spend proceeds on the projects that voters approved and do so efficiently. But how are oversight committees supposed to go about that? I think that there are two steps. One is sort of figuring out whether the district complied, and two is to communicate the results of that to the public. So in determining whether the district has spent bond proceeds efficiently and according to the bond measure, the committee gets copies of the annual independent performance and financial audits. So the performance audit is geared at determining whether the district spent bond proceeds on voter approved projects, and the financial audit is intended to ensure that the district has fairly presented in all material respects the finances of that particular measure. In addition to reviewing these audits, the committee can also conduct site visits to ensure the projects are of the type voters approved, review deferred maintenance proposals, and obviously be in communication with district staff. The two audits, I think, are the principal place where oversight committees should begin their analysis, because you have, licensed public accountants who are providing an opinion as to the district's compliance. And I think that when oversight committees read those audits should carry the presumption of both accuracy and completeness, and should only be questioned or contradicted if there is specific and credible information that the district has that contradicts the conclusions in the audits. In addition to reviewing those, the committee should be familiar with the bond project list. This is the the language that went to voters that told voters what the district was going to spend money on. And ultimately, I think that this is the covenant with the voters. And the Oversight Committee's primary responsibility is telling the public whether the district has kept trough with the public and spent the money on the projects that the bond project list includes. The district, it's worth saying, is prohibited from spending money on any projects that aren't on the bond project list. The Attorney General and the Constitution and state statute have all said that you can't spend bond proceeds on teacher salaries or other operating expenses, which seems like a pretty easy rule to understand until you read the Attorney General opinion that I've cited here, which says that districts can pay district employee salaries to the extent that they're performing work that needs to be done on bond projects. And so that means that, for example, instead of having an outside project manager, the district could pay somebody in the facilities department to be the project manager and could use bond proceeds to fund that position, so long as that position was only doing work that was related to the bond. The committee is required to produce an annual report, and the district is required to publish the annual report, plus any reports received, the 2 audits that we've discussed, and the committee's minutes, plus any other relevant documentation on their website. The committee may, but isn't required to make oral reports to the board from time to time. And the committee, like all boards and committees, should speak with one voice, and absent delegation by a majority vote of the committee, that one voice should be the chair's. Does anybody have any questions so far?
Mr. Palmer, I don't have any questions about what you just talked about. So I'll save my questions about other things till you're done.
Okay. Anybody else? Okay, I will continue. I apologize, I can't see you while I'm presenting, so if you would like to ask a question or interrupt, please do so vocally. So now let's talk about the Brown Act briefly. The Brown Act is our California sunshine laws, and the intent of the laws taken together is to ensure the public agencies deliberate and act in open view of the public. So what's a meeting? It's any gathering of a majority of members to hear, discuss, or act on any item within the body. Sorry, was that a question?
No, I coughed, sorry.
My apologies. So it's any gathering of a majority of members to hear, discuss, or act on any item within the body's jurisdiction. So if a majority of you find yourselves together at a non-agendized gathering, it's important to ensure that you don't hear, discuss, or act on any item within your jurisdiction. Generally, your meetings should be regular meetings, which must be set in advance, held within the jurisdiction of the local agency, and you must post an agenda at least 72 hours in advance. The agenda needs to briefly describe each item of business and be posted in a location freely accessible to the public and on the agency's website. No discussion or action may be undertaken on items not appearing on the agenda. The legislature takes the Brown Act seriously. It says, that complete, faithful, and uninterrupted compliance with the Brown Act is a matter of overriding public importance. If there are mistakes made, which happen, especially, as we've seen, because the, for example, teleconferencing rules got very complicated during COVID. The committee can cure Brown Act violations by issuing a letter promising to cease and desist from repeating the violation. If the committee doesn't do so and the district is forced by a court to issue such a letter, the district could be on the hook for court costs and attorney's fees. Faithful compliance with the Brown Act is not only a legal requirement, but it's an integral element of the code of conduct. And failure to comply with the Brown Act is grounds for removal. So a little bit more about remote meetings. So generally, meetings should be in person. Members may join remotely if the agenda includes each location where a board member is located, and each location is accessible to the public, and agendas are posted at each location, and a quorum is present within the agency's jurisdiction. So that's the traditional Brown Act rule that has always existed. There was a state of emergency set of rules, but those expired, and that was AB, I think 361. Those expired at the end of 2023. And then there's sort of an interim set of rules which will go until the end of 2025, I believe, and that was AB 2449. And that has a special exception that we've discussed a little bit already tonight, which says that members may appear remotely in an emergency up to 2 times a year if the committee makes a finding of just cause and the member participates with audio and video.
Mr. Palmer, can I ask a question about that?
Please.
Okay, you just said, would you repeat what you just said about the member attending remotely if the committee does what?
So, okay, here we go. So I'm going to be a little bit more specific than my slide. Individual board members can participate in board meetings remotely if they notify the board at their earliest opportunity and have one of the following. So either just cause, and just cause is individual board members can participate remotely when caregiving of a family member, or if they have a contagious illness, or a mental or physical disability, or LEA-related travel prevents them appearing in person.
Can I ask you about that?
Sure.
So if the member has one of those conditions that you just described, the member required to explain that to the committee, or does it only need to be his secret reason?
So under just cause, there's no requirement that they disclose to the committee in public which reason they have for attending remotely. But I think that implied in the statute is that when they notify the committee at their earliest opportunity that they won't be in attendance, that at that time they will disclose why. That's different than emergency circumstances. So if you're using emergency circumstances, individual board members can participate remotely when there's a physical or family medical emergency that prevents them appearing in person. And here, the board member must describe the emergency in approximately 20 words without disclosing any personal medical information. And the board must take action to approve the member's request. A board member cannot claim emergency circumstances for more than 3 consecutive months or 20%.
Let me interrupt you again and ask a question. So you said that the board members must approve the medical emergency, must approve the application to attend remotely?
So there are, under AB 2449, there are sort of two separate ways that a board member can attend remotely. One is if they have just cause and they've let the board or committee know in advance that they won't be there for one of the just cause reasons. And the second one is under emergency circumstances. Under emergency circumstances, there's no requirement that they notify the board or committee in advance. But if they haven't notified the board or committee in advance, the board member has, the remotely attending board or committee member has to describe the emergency in approximately 20 words, and the board must take action to approve the member's request. And so if we're under
When you say must take action, does that mean there's going to be a vote or a discussion, or what does action mean there?
Yeah, that would be a vote.
Okay.
So if you're under emergency circumstances and not just cause, then the committee member attending remotely needs to briefly describe what the emergency is without revealing any personal medical information, and the committee or board needs to vote to permit them to attend.
Okay.
But under just cause, no vote is required, but advance notice is.
Okay. One of your earlier things you said I would like to clarify, and that is when the person that's going to wants to attend remotely needs to provide his location. Isn't that only when there is not going to be a quorum in person at the meeting? You can answer yes or no. I don't know. I don't have a preconceived answer to this. I'm just trying to clarify my understanding.
I'm sorry, could you repeat your question again, please?
Okay, so if a member intends to attend remotely, and there's going to be a quorum at the district offices, does that person need to disclose their location?
I don't believe that they need to disclose their location unless they unless they're acting under the traditional Brown Act teleconferencing requirements. I think that if we're under AB 2449, the agenda simply needs to identify and include an opportunity for all persons to attend via a call-in option or an internet-based option. There's no requirement to disclose the teleconferencing location.
Okay, thank you. I was trying to clarify that because Mark had said a few things that made me wonder about it. And I think Andrea would like to ask you a question about this also. So Andrea, do you want to ask Mr. Palmer a question about this?
I do. I just would like you to maybe further clarify it later, because in this particular case that we've discussed this evening, before we actually voted to even have a quorum at this meeting, the discussion came between the chair and the district and Mr. Herbert, before we had a quorum, which I think that was not correct. We haven't even acknowledged the meeting had a quorum to start to have a discussion. That's one thing. But the other thing is AB 2449. Could you just please look it up and clarify, because that a person of the public doesn't have to be able to, in other words, go to your address. So because
Right.
the 72-hour posting has to be posted at that address, the way I've understood it. Could you go into more detail on 2449?
Sure. 2449 doesn't have a requirement that a board member who is attending virtually because they have satisfied either the just cause or emergency requirements notice their location. The requirement to notice the location and to have the agenda posted there and have it be publicly available is one of the traditional Brown Act teleconferencing requirements.
Right, Mr. Palmer, I think Mark Johnson would like to ask a question.
Thank you, Chip. Mr. Palmer, now that Governor Newsom ended the COVID state of emergency, are we back to the pre-pandemic rules for noticing address before attending remotely?
So, yeah, I'm sorry that this is super confusing, but it's not you, it's the state of the law. So, the end of the declaration of the state of emergency also sort of brought to an end the AB 361 requirements. And so now we're under a regime where we generally have to comply with the traditional Brown Act requirements, but there's still AB 2449 that will be effective, I think, until the end of 2025. And so under AB 2449, board members can attend meetings remotely if they either satisfy the just cause provisions or they satisfy the emergency circumstances provisions. And so if a board member is because they are taking care of a family member, they have a contagious illness, they have a disability, or the district requires them to be somewhere else, and they notify the committee in advance, they can attend meetings remotely up to 2 times a year without satisfying the traditional Brown Act teleconferencing requirements. But if they don't meet the just cause or emergency circumstances requirements, or they've used those up, so they've already used them for 2 meetings in a year, or they've sort of had the emergency circumstance for more than 3 months or 20% of the meetings of the year, then they need to satisfy the AB 2449, the traditional Brown Act requirements. And if they were under those, then they would need to be in a publicly accessible location with an agenda and all of that. Does that answer your question, Mark?
It does. Chancellor Gilchrist, did you have a comment?
I was trying to clarify just that he met the threshold for the traditional Brown Act by posting the agenda, location, and that. So yeah, you can do either, right? Like, as long as that I just want to make sure that that's clear.
Did you hear that, John?
Yeah, my understanding is that you did meet all the traditional Brown Act requirements for the meeting. Yeah.
Thank you.
Yes.
I also have another question if nobody else has a question right now. My question is, if a person is a committee member is attending remotely and the video is only an empty room, is that committee member still attending, or could he just say that he has left the room? So what does participation mean there?
I mean, I think that, this is a situation where we would want to apply the substantial compliance doctrine that one of the other committee members raised. Obviously, if you need to get up to attend to some matter quickly, or you need a bio break, I don't think that invalidates your participation. But if your camera is on the entire meeting and nobody can see you, and you participate in the meeting without being seen, I think that would arguably be non-compliant.
Okay. Thank you. I have no more questions right now. Would you
Thank God.
continue, please?
Okay, so the Brown Act, it is serious business even for the committee. Mark is your first point of contact. He has access to counsel if needed to ensure compliance. I think that the district will look on non-compliance with disfavor and may exercise its removal remedies if committee members don't comply with the Brown Act. And if you discover that you have inadvertently been non-compliant, it's important to remedy it ASAP to avoid litigation that can be costly for the district. And remember, that's just a letter that says, hey, we realized that we made a mistake and we promise not to do it anymore. So I was hoping to talk about bylaws a little bit. So generally the bylaws for oversight committees across the state follow the statute and try to fill in some operational blanks. I think that the value of bylaws is in being a little bit more explicit about what the sort of limits are on what the committee can and can't do, and also providing a little bit more detail on how the committee operates. So we can see in the bylaws that the committee can't direct how bond dollars are spent. They don't participate in the bond sale. They don't require additional audits, and they don't hire their own lawyers. These restrictions are implied by statute, but made explicit by the bylaws. And I think that you guys had 15278 as an attachment to this meeting. And you can see that the legislature has said in order to further its purposes, the committee may engage in one or more of the following activities. And then there's a list of activities. And in the law, we generally apply a principle that says if you state one thing, you're intending to exclude the others. And so when we apply that to 15278, we say the list of activities that the committee can engage in is the full set of permissible activities, not just a representative list, but actually the complete list. And that's sort of where those restrictions are implied by the statute. The board of the district is responsible for appointing members to the committee, removing members for cause, providing administrative support, and amending the bylaws. Faithful observance of the bylaws, like faithful compliance with the Brown Act, is an essential element of the code of conduct, which is an appendix to the bylaws. And failure to observe the bylaws is also cause for removal, as is failure to comply with the Brown Act. The bylaws say that the committee should meet approximately quarterly, and that seems to be the rhythm that most oversight committees that I work with operate on. I think any more than that tends to be unduly burdensome for committee members, and any less than that makes it difficult to work through all of the information and provide a comprehensive report at the end of the year. I have this slide called "Working Together as a Committee," because bond oversight committees have become more fractious, I'd say, in the last 5 years. And so I think it's important for the committee to really pay attention to the purposes and the activities that we've discussed and that are enshrined in statute and the bylaws, and make sure that that's really what the committee is doing. That I think that ensures mission alignment and provides a helpful lodestone when conflict arises. The committee's charge is retrospective and not prospective. So the committee doesn't have any power to direct the district or its employees or the expenditure of bond proceeds. What the committee does is look at what the district did and then report to the public about whether it was compliant with the bond project list and the other constitutional and statutory requirements. The committee works according to bylaws adopted by the board, may suggest but not adopt changes thereto. That's in our bylaws. And when I finish this, and I think I only have maybe one more slide, I can give you a little background on how this is played out over the course of Prop 39, right? We're 23 years in now. The committee should meet regularly with advance notice to ensure quorum. And if you are a committee member and you can't attend meetings regularly, I think it's important to acknowledge that and resign your seat so that somebody who does have the time and energy to make the meetings consistently can participate in the committee. And I don't think that there's any shame in that. We all get busy or focused on other things for a variety of reasons. But when it does happen, I think that good citizenship is to acknowledge that and be sort of clear with yourself about whether you think this is a brief interruption or sort of a more permanent state of affairs. And if it looks like it's going to last for a while, I think it makes sense to resign the committee. And then obviously the most effective committees are cooperative and not antagonistic. So my short list of do's and don'ts, which didn't format very well on this, do know the project list, do ask questions, do participate actively, do know your bylaws, keep it professional, cooperate with each other, be conscientious of staff time, and have fun. The staff time issue is I think particularly worth noting because the district employees who staff oversight committees have sort of full-time jobs before you add on staffing the oversight committee. And I think that all of the staff members that I know across the state who staff oversight committees really want to do a good job and want to answer all of the questions that are posed by the committee. And so I think that as committee members, it's important to acknowledge that and be judicious about how much information and time one asks for. And the sort of most effective method that I've seen of doing that is making sure that the committee members pass all of their sort of requests for information to the chair, and that the chair and the staff person are able to work together to prioritize those requests. My don'ts list, which didn't format here, was don't lose sight of the committee's charge. I think scope creep is natural for oversight committees. Like, it happens everywhere. And I think that the best way to avoid scope creep is really by returning to the bylaws and statute with regularity to remind everybody of the purpose and scope of the committee. Don't create busy work for yourselves or staff. Don't forget about the public, because ultimately the job of the committee is to let the public know that the district is spending bond proceeds efficiently and on approved projects. Try not to get your blood pressure up. Sometimes it can be frustrating, but remember that, you know, we're all here because we sort of care about local democracy and public agencies, and we want to make the relationship between the public and public agencies better. And you know, don't forget what you don't know. You know, asking questions, I think, is always helpful. So with that, I will thank you for your time. I'm going to take down my presentation, and I'm happy to discuss anything that you would like to discuss.
Mr. Palmer, thank you for your presentation. I think that the question about remote participation might come up again, and so we might have some written questions for you. I hope that we don't have disruptive meetings because of the lack of clarity on remote participations. And if nobody on the committee has a question, we will call this agenda item done. Yes, Jeff?
So, John, I just have a quick question. You had said in your presentation that districts do have the authority to create bylaws for the committee.
That's right. You know, I will say that has always been, I would say, the majority practice in the state. But in the early days of Prop 39, there were some districts who chose to adopt a board policy and associated regulations, and then permit the committee to adopt its own bylaws, but within the scope of what the administrative regulation and board policy permitted. I'm not sure that there's really a substantive difference there, but I think that minority approach did allow the committee a little bit more flexibility over its operations while retaining the proper amount of supervision of the committee.
Okay, thank you.
Okay. Mark, do you have a question or a comment?
I have a comment. Thanks, John. About the bylaws and the relationship between the committee and the board of trustees that set the bylaws. At Peralta, there's a precedent where this committee requested a change in the bylaws, and the board of trustees approved that change. So when this committee was created with board action and creation of the bylaws in 2019, and when that happened, the initial term for members was set from March through February, and it was kind of confusing because our fiscal year runs on a July through June schedule. And when this committee first started meeting, the committee recommended to the board the change to move terms to our fiscal year, and the board accepted that feedback, made the change. So just putting that out there.
Thank you.
And I would just reflect that that's consistent with what I see across the state.
Ben,
I just have a quick question. You made a comment about committees not hiring their own lawyer. How is that possible to not do that and remain independent or flexible?
So I think that I guess I have a three thoughts to sort of share on that. The first one is that I think that the Oversight Committee was intended to be a representative body of the public, and sort of a to give that representative body of the public, who I think wasn't assumed to have any special knowledge, a voice to opine on whether the district had kept troth with its voters. And so the I think that the intention was to say, if I, as just a lay member of the public, am sort of given access to additional information, do I, in my lay capacity, think that the district has done what it said it was going to do? And then, you know, the committee made up of a few members like me are supposed to sort of publish an opinion about that. And I think that there are a number of situations in which you know, oversight committees have actually caught fraud or abuses, not by virtue of having any special training, but just being independent members who are overseeing the district's expenditures. And I think that the sort of statewide committee on bond oversight committees has a presentation that they've made where they go into detail about a couple of those instances. But you know, I think that those instances weren't instances that required any sort of special training. They just required you know, a group of people to be paying attention and to have a voice to communicate with the public. So one is, I don't think that committees are intended to bring any special expertise. The second one is that lawyers are expensive, and the district has to pay for them because the committee doesn't have a source of additional money, and the district is already paying for lawyers, right? And the district's lawyers, who they're currently paying, are in the business of advising them on what expenditures are and aren't permissible. And so I think just from a resources perspective, having a shadow set of lawyers who are going to probably be trying to disagree with the district's lawyers because they would like the district's business is likely to create more problems than it's going to solve. And then and you know, there I know of at least one district that in Southern California that gave its oversight committee a legal budget, but the oversight committee generally, I think, didn't use that legal budget, and then when they did, they ran into the ceiling pretty quickly, and they got upset about it. I think that there is a potential situation where the committee and the district are in conflict over the permissibility of a particular expenditure. And I think in that situation, you know, if the committee and the district are at odds, it's not appropriate for the district's legal counsel to be providing counsel to the committee on that question. but I think that the proper path forward for the committee, rather than hiring its own lawyer, is to include its concerns in its report and to say, you know, we reviewed these expenditures, we asked questions, we got this answer, but we don't feel like the answer is correct. And so we're noting that for public consumption. But I think that, you know, so those are sort of my three reasons why I don't think that committees should be in the business of hiring their own lawyers, and what I think committees should do if they don't feel like they're getting good legal advice from the district's lawyers. But I also acknowledge that there have been districts that have tried other approaches, like the district that gave the committee a legal budget. But, you know, again, in my experience, 99% of the committees that I am either working with or aware of don't have independent legal counsel.
Did that answer your question? Yes. Okay. Thank you, Mr. Palmer. Are there any other questions from our committee for Mr. Palmer? Hearing none, this agenda item is done. Thank you very much, Mr. Palmer, for your call.
Thank you very much, Mr. Chairman and committee members. I wish you a pleasant evening.
Thank you. Moving on to the next agenda item. Are there public comments regarding agenda item number 6? Okay. Hearing none, we will proceed with agenda item number 6. And I move that we discuss and vote on the question, is this BMOC independent in fact? Is there a second? Okay. The motion's been made and seconded. We should begin. I'd like to make an introductory statement about this. Based on my conversations with Mark Johnson, it occurred to me that some folks might think that the Oversight Committee is independent and doesn't need to discuss the topic of independence. And it is a waste of time to even talk about it. And those folks might argue that the education code requires that no district staff be appointed to the Oversight Committee. And therefore, the committee is devoid of district staff, and one would say then therefore is free of district staff, and therefore is independent of district staff, and therefore it is independent in fact. Now there might be other opinions about this question, and if this Bond Oversight Committee had a lawyer that represented the best interest of the Oversight Committee, a lawyer might say something like, well, the Education Code 15278 requires the Oversight Committee to be independent. And the Education Code 15282 Section B says that there shall be no district staff appointed to the Oversight Committee. And if the Education Code 15282 with no district staff meant that it is thereby independent, then that would make the 15278 statement of independence superfluous. And if we had a lawyer that was dedicated to the best interest of the Oversight Committee, he would say that the Supreme Court has ruled numerous times that there are no superfluous words in a statute. So therefore, having a committee that is devoid of district staff and a committee that is independent are two different things. And therefore, independence and devoid of staff are not the same thing. But we don't have a lawyer that is dedicated to the best interest of the Oversight Committee. The district lawyers are professionally required to state the best interest of the district, of their employer. And that makes a lot of sense. Since if our lawyer was talking, he would probably say, well, you know, the district lawyers have set up this set of rules that says we will tell you what to do and that you are independent. And we will also set up a set of rules that say that you cannot get legal advice from your own independent lawyer. And so that's sort of sounds like the old Catch-22 from the 1960s, a famous book. And the Catch-22, what the storyline was there were bomber pilots during World War II over to Europe, and they kept raising the number of missions that the bomber pilots needed to go, or the entire crew needed to go, from 40 to 45 to 48 to 50, and every time they flew another mission and were just about to be able to retire, the bosses would raise the thank you for muting him. If this preposterous situation kept on and the crew got sick or went crazy, the Catch-22 was that, well, if you are crazy, then you're not capable of making an intelligent decision, and therefore we will make the decision for you, and our decision is you need to fly more missions. And we have a similar situation here with the independence of the Oversight Committee and having legal counsel on whether or not we are independent. So that said, I would like us to talk about what we think the word independent means. And I did include in the attachments what the California Association of Bond Oversight Committees has reviewed as important questions. And we don't need to believe those or follow them or anything. It's just a document there to stimulate your curiosity for the conversation. So so that said, I think that we should discuss whether or not we think that this committee is independent. And one of the items on this recommendation is that, for example, do we set our own agenda? And the answer is no, we don't set our own agenda. The bylaw says that we set the agenda is set by the chair in consultation or cooperation with the district, and therefore the district has the final word. If the district has the final word, the district is setting the agenda, not the chair. if the district can impose additional agenda items on our committee, well, then the district is in charge and the committee is not independent. That is, that said, does anybody want to say something about whether or not, and I'm going to request that we stick to one topic at a time. So if I now just introduce the issue of, do we have an independent agenda? Let's kick that around a little bit until we don't have, and then move on to something else so that we have some bit of organization of our thoughts here. Does anybody have a comment about the drafting the agenda and setting the agenda from our committee members? Okay, well, then does one of the chair does not recognize the vice chancellor to speak on this. This is a committee member meeting and the committee members will talk.
Okay.
Thank you. So Jeff, yes.
So I want to clarify something because 15278 does mention an independent citizens oversight committee.
Yeah.
Also, but section B limits what it is that we do. And it says the purpose of the citizens oversight committee is to inform the public concerning the expenditure of bond revenues. So as long as there's no interference with that overall purpose,
Yeah, but
we're not independent on everything because we get other resources from the district.
Jeff, that's not exactly what the 278 says. It says that they shall do this not limited to these things. So it doesn't say that this is a list of things to do. It says that as an independent oversight committee, and it reports to the public, and these are some of the things that the oversight committee could do and should do.
Now, we have limited jurisdiction on the things that we can do. It's very specific about what we can do and what we can't do in the statute.
No, it's not. It says not limited to.
We'll disagree.
Well, I think we have the statute right here. Let's see if the statute does say not limited to.
It does.
Okay, all right. So it says not limited to.
Yep, but we don't have unlimited jurisdiction. We
Right.
can't just pick and choose what it is we want. It still is within the scope of the purpose of the Citizens Oversight Committee.
Okay,
We can't go to the governor and do many other things. So it's implicit in the scope of what our charge and purpose is.
okay. So what does the word independent mean?
That's your question.
Oh, okay. So you don't want to weigh in on that. Okay. Is there anybody else here on our committee that wants to comment about the meaning of independence? Yes, Jill?
Well, just to Jeff's point, what he was saying, so Jeff, if I could understand, so like charge and purpose, meaning how the original voter language was put in on the ballot and what the voters voted on. That's what you're talking about, as far as like how that was, because that's specific to.
How money was spent, right? And what the project specifically was. So we're not talking about that. We're talking about how we do our job.
Right, but to a certain extent, isn't that called for in the ballot language? Like when they say, okay, we're approving this bond, or we're approving this parcel tax, in this case, this bond, we're approving this bond. And with that, we are going to be setting up a committee. And the committee is going to have oversight and tasked with these responsibilities. Like it's a very general thing that is laid out in the ballot language, correct? Is that what you're talking about?
And then our charge then is under statute.
That comes from the state.
From the statute, yeah, 15278.
Right. So, if I'm understanding what you're saying, so like, again, ballot language is telling us that a committee is being formed, the committee is going to be overseeing how the money is spent, because that's already part of the language that voters see.
Yeah, I'd actually have to see the language. I don't know specifically what that language says, word for word. The ones I've seen in the past, have just simply said pursuant to like statute.
Right, but it's not like we're gonna be talking about, we want the baseball field over there. We're talking about like, how are they spending? I think that's how it's laid out in most of these bond measures when they're put forth in front of the public, right?
Yeah.
It is about the money concerns. So I agree with that. But then when you're getting into what the state is now saying, okay, now you've formed a committee because you had this bond approved and that was in the language. Now these are the rules or the statutes you have to follow for all of those types of committees.
Your jurisdiction.
Your
basically.
jurisdiction,
Yeah.
yeah. So that I approve, I agree with as well. But within that, to Marcus's point, I think what he's saying then is if we're reading that, it's saying now with that overlay, you can go create your bylaws based on what we've laid out in 15278, if you want to. If you want to work with your college district and they provide you bylaws and you're fine with that, you can do that. But if you want to create your own, you're within the jurisdiction of the statute language. At least that's the way that I read it.
Could be, yes.
So,
Mr. Chairman, may I be heard briefly on this matter?
No, you may not. So this is a discussion for the committee. Ben, did you have a comment you wanted to make? I saw your hand. Andrea?
Well, so the attachment that you gave us, I forget his question, frequently asked questions out of the K-box, which is, I know that you're on the board of the K-box, which is the California Association of Bond Oversight Committee. I actually happen to be on that as an advisor too, at that very same committee. So there's 44 questions, and you pick the one to attach to. Basically, these are the questions that we ask if whether the committee is independent or not, right? That's what you attach. Okay. So there's other questions that I think further explain, in particular, what you're speaking to, Jill. And question 12 is an interesting question, I will say, out of the K-box bylaws, okay? And what it says is, can a school district dictate the bylaws of a bond oversight committee? And it says, I'm reading it verbatim off of the website. Okay, bylaws.
Yeah, I'd like to interrupt you.
Why?
You've changed the topic.
No,
We're talking about independence, and now you want to talk about the bylaws. We're not talking about the bylaws right now. We're talking about, is our committee independent? And the topic of that I brought up was, can we prepare our own agenda? Now, if we're done with discussing the topic of can we prepare our own agenda, let's move along and talk something else about independence.
I thought we did move along too, but nobody had a comment. And I thought, and so we're talking about something else now. And how were we created to be independent? And so, and it's Ed Code
And we talked
15278.
about
Okay.
bylaws last meeting. So let's talk about independence this meeting, not about bylaws.
I'm done.
Point of clarification, please.
Yes, Jim.
Yeah, so you brought up a provision in the bylaws, because the agenda item is in the bylaws. So the bylaws generally are the topic that we are discussing. You cannot limit that.
Yeah. Well, Jeff, yes, I can. If the agenda, if the topic gets too far from the agenda item, we are no longer talking about the agenda item. We're talking about independence. We talked about bylaws last time, so let's talk about,
You brought up
other.
you brought up the agenda and creating the agenda specifically. That is in the bylaws, that is a provision of the bylaws, and you're saying that that provision is not valid because it attacks the independent. And so that is properly before this committee.
Okay, is there something else you want to say about that?
But you need to rule on that, please.
No, I don't need to rule on it.
Well,
Thank
I'm
you.
leaving.
Excuse me, would you, at 7:15, I am now leaving the
I am
meeting.
too.
Yeah, I think I will as well. Good night, you all.
Sorry, Chancellor.
Yeah, sorry you had to see this display tonight.
Okay,
You don't have one.
so, next. Can we meet anytime we want? That is one of the questions of the topic of Are You Independent? Now, the bylaws of this district that are imposed on us says that we're supposed to meet approximately quarterly. We have decided that what we need to do until we catch up is meet every month. So far, the district has not given us any flack about that, so I'm real happy that we have not had any problem with that. And I think that if we actually look back over the 4 years that we have been, we did not ever meet more than 4 or 5 times. So even though we seek to meet 5 times a monthly, we do not even closely achieve that. So, are there any comments regarding, can we schedule meetings anytime we want? Okay. The next item is we approve.
Excuse me, I have something to say about that, and so does Mark as well. Well, there's no need for us to meet other than the times that we have been meeting, and we can even break those times roughly throughout the year. I've been at the beginning of this committee along with Marcus and Andre. We have never met more than monthly, and that is actually pretty exhaustive, as you can see tonight, and unnecessary, as you can also see tonight. There is no need to meet more than the times we have already met. And in fact, I will recommend we meet even less than that unless there's actual business that we can actually meet about, as many of us on this committee have served on other committees and board before. Thank you.
Okay. Mr. Herbert, you're addressing the topic there of can we meet whenever we want? And so thank you.
Well, we're scheduled to meet monthly, so it's not necessarily whenever we want. It's scheduled every second Wednesday of the month. So that is occurring. What I'm saying, we can go back to the original format, which is meeting whenever we want. That was what we were doing originally 4 years ago, but we have not done that as of late.
Let me ask you a question there, clarification. You said that meeting twice a month?
I said we don't have to meet twice a month. I said we're meeting monthly. And that is the question that Mark, who has his hand raised, would like to answer as well too. But to further address what you're stating, the point of this particular motion is the fact that we don't have to even meet monthly unless we're getting to the business at hand of what this committee is supposed to be meeting about, which we have not actually even scratched the surface about.
Okay, so then we can meet anytime we want. Is that correct?
No, you're saying we cannot. No, listen, you're saying we can. Yes, we can by the duration of a vote. We don't even have enough members to vote on it tonight. We can and should probably meet when we are able to all meet to discuss matters of which we are to meet about. Is that clear enough for you?
Okay. Yes.
I
Then
actually,
you have the
you said,
floor.
I don't think we're in disagreement. I think he was actually saying it's great that we meet monthly. So I don't think we're having a disagreement. I think.
Oh, that's good for once. But I'm saying that we don't even need to meet monthly unless we're going to actually meet about actual business matters and things that we could discuss in a public setting where people are here on Zoom. We should only be able to meet about the matters on the agenda and not dovetail into these extraneous things that are irrelevant.
But
It's a waste of everybody.
So far, we are meeting when we like to, and the staff has been.
This is the first we have done that, Benjamin, in a long time. Okay, you're not probably familiar with this committee as I have been, so you probably don't have the history and experience with this committee. So I'm glad to see that we actually are getting through to the actual attorney at hand, and hopefully we'll be able to get with Sharon. My point, just simply to state, is that we don't have to meet as monthly as we have been, period.
Okay, thank you. So, are there any other comments regarding this agenda topic? Are we independent in fact?
And we have almost 10 more minutes, excuse me, so we could really get to Sharon's presentation, which, as of late, as usual, is the last thing on the agenda. And I would like to promote that to the higher part of the agenda for next month or whenever we meet again, agenda as well, too. And
I'm sorry, Mr. Herbert, the chair asked me to mute.
Okay, Mark, I'm going to give you the floor.
Thank you, Mr. Chairman. So 2 members of the committee departed at 7:15, so you no longer have a quorum physically present in the room. So you're not able to vote.
We do have a quorum. We had a quorum, and Mr. Youssef is still present, so we have a quorum.
So I understood Mr. Palmer's presentation to say that remote attendance was okay, but there needed to be a quorum physically present in at the location.
Okay, well, in that case, we should adjourn. Well, let's see. We can't vote on this agenda item, but we can continue and have a discussion. And so therefore, we could have an update on construction progress. Let me see the agenda here and see what we have going. Yes. So the meeting is not adjourned yet. So let's have a we're going to move to agenda item number 7. And that is a construction progress report from V.C. Smith and Sharon Serrano.
Okay. Well, as you know, AECOM is our PMO, our project management organization for the bond. So Sharon tonight has come to give you an update, the committee, an update on our expenses today.
Okay.
Happy New Year, everyone. Number 1. And I'm gonna go through my presentation pretty quickly. Apologize, I only have 7 minutes. So I will share this presentation with you at the end of this meeting. There'll be PDF and you'll get it tonight, so you can review it at will on your own. So let's start with the first summary page. This is a really high level view of where we are today with the bond program. The first column, or column A, is your projected budget for all our projects. We have a total of $902 million to date. Total commitments, these are contracted amounts. Expended to date is the amounts that we have paid out the door, checks out the door. Just want to make sure I'm using very understandable explanations. And then the remaining balance, of course, is your project budgets minus the checks that went out the door, or column C.
To date, we have sold $235 million worth of bonds. The first tranche was 115, which was a combination of Measure A and Measure G. And then we sold $120 million for Measure G, and that equates to $235 million in total. Contracted, it's been 29% of what we have sold, or what 29% of the projected budget, and we expended 15% of the projected budget. Next item is College of Alameda. I focused on the major capital projects first and foremost. I'm sorry it's so small, but it's the only way to combine information, the dollar financials with the actual schedule, a very quick overview of the schedule for each project. As you know, we have the new Center for Liberal Arts, design build project, that has been completed. And if you haven't had an opportunity to go visit some of the sites, I believe we did a tour previously with some of the board members, with some of the committee members already. We have also the auto diesel project. You can see a combination of funding sources for that auto diesel. It's at 41 million. Aviation complex in phase 1 is a design build project. It is 12 million. It's a combination of Measure G and Measure A funding. You guys requested the definition of how projects are being funded, so I have provided that information for you. I've also defined where state funding is also included in there as well. Aviation complex phase 2, which is hangar A, is $41 million. It includes Measure G funding as well as the state match of 12, and then of course a Measure A of 1.7. New science and admin building, we have coined that a phase 2 project. We have divided the bond program into 2 phases where we're moving first and foremost with projects that were state funded, where we want to make sure that state funding matching dollars are not lost. So we proceeded with those projects first and foremost. And if you can look at the right-hand side where it breaks up the quarters per years of where the projects are at this point in time, you can see that first and foremost, the blue or the turquoise color is when we secure, and the orange is the design phase. The red is DSA, or Division of State Architect, is when they review the plans that have been designed by the architect. And of course, green is construction. Now the hash marks at the very top of each square, see, sorry, it's so small. Those hash marks show the original plan, the original schedule. And then
show me what the hash marks are again.
the hash marks up here.
Oh, okay.
So you can see what was originally projected, and then this is where we are now.
Okay,
Okay, the square block.
yes.
So also the committee had requested that I also include the other projects that are included in the bond measure that are above and beyond capital projects. So here's College of Alameda. I had said, provided a listing, but this time I provided a listing of the actual projects, the status of the projects, if it's complete, as well as the total project cost of each project. So for example, there's going to be a lot of these projects, so if you guys have questions regarding, please stop me. But for example, there's a project we had listed down as infrastructure. We included several smaller projects within that infrastructure description, which can include elevator upgrades for all the campuses, roofing repairs and replacement. There was an aviation sewer pump replacement, and we can go farther down. So each campus has one of these, well, multiple infrastructure slides, so you can see where the monies are being spent and if these projects are complete or ongoing. If it doesn't show complete, it's an ongoing current project. Okay, so the next project is Berkeley City College. The phase 1 project in Berkeley is the Milvius Street project. That is the new 6-story building that is kitty corner of the existing campus right now. It is slated for $86 million. And then the phase two Berkeley City College is the existing Center Street project, which will be basically remodeled to a certain extent, interior remodeling for those particular departments that have or will be moved to the new Mill District. And the focus of the reconfiguration of the Center Street is science labs. Okay. So included with that, here's Berkeley's list of infrastructure projects. We have a few of them complete. As you can see, there are some similar projects like the elevators, keyless entry, door repairs, and so forth. But the list of projects that were provided by the campus to the PMO to create these lists of smaller projects. Next one is Laney College. For the phase one projects, we have the portable modular village, the Laney locker room modernization, the East Bay Mud water main relocation, the central plant or the CUP central utility plant project, which we named also Central Plant Cooling Tower. The Learning Resource Center and the Laney Theater modernization. Those are all phase one projects. The total project costs are listed down here. The schedules are shown on the right-hand side. The STEM building is phase two. So that has not started at all.
STEM, those means what?
Science, technology.
Engineering, math, and math.
And if I can just interject for a second. Just understand when we said phase two, it's important to know because of COVID and escalation, we're waiting to go on to projects to have a clear understanding of what's been spent and what's available to go on to the next projects. So before we start a project, we also make sure that we have enough to finish. So that's why we divided it into phase one and phase two.
When you say that, like, you have enough to finish it, that's without any change orders or?
There's contingencies. There's also things with change orders. But I'm saying that it's important for us to address what the actual costs are because there's been significant. Some of these projects were scoped out 10 years ago.
Right.
So the cost of when it was scoped out 10 years ago and the cost of what it is now, there's a difference. And so you see it's reflected in the cost now. So that's when we bid it, because what we may think the scope may be, or what we think the cost may be, then we get the actual cost. You don't get cost until you get a contract and an actual bid. That's how you know where you are with your projects. And so we're not moving forward with other projects without clearly understanding and having a grip on all the projects that we started in phase.
And then within the 10-year span that you're talking about, from like initial budget to potential completion, separate from the cost and the contract being signed, could it also be like, oh, we're adding a wing to
No.
now to it?
No. So let me give you a little further clarification. For example, the Laney Library, we started costing that maybe 10 years ago. We estimated that cost. We are just now finished designing it. It's just gotten approved by the state, DSA. And so now we're ready to bid the cost of what it's actually going to, what those fees, what those costs are going to be. So in real time. And so there's also escalation that we're going to have to anticipate. There's a lot of other costs that we may have to build into that. And that's what those numbers reflect. So it might have cost you 10 years ago, $65,000. But now it's going to cost you $75,000 10 years later. So that's what the PMO and the staff has accounted for.
Well, a library for $75,000 sounds
Yeah.
really.
No, I'm sorry, 75 million. Sorry.
On the Bible or two.
Library for everybody.
Exactly. Okay, so, Laney College, we have, we went over the phase one projects and then of course the STEM building is phase two, just like Theory had mentioned, we did purposely create a pause between the phases. so we can reassess the values that we are projecting for these numbers, right? The estimates that, the budgets we created based off estimates, and then the estimates once again, right before bidding, and literally when we bid the documents, what the contractor is providing us. So there's multiple phases where we constantly look at those values to make sure we do not start a project that we cannot afford. Period.
You know, and there's a couple of other things I wanted to add. Sharon had mentioned we're not starting a project that you see the time frame it takes us to get these projects initiated, constructed, and finished. In that time frame, we also work with the colleges because they are working on their educational master plan. And what was great 5 or 10 years ago is not so great now. So we have to make sure that pause also indicates what is important to the colleges in order for them to deliver instruction. And that instruction can change in 5 years. COVID
Has
in
changed.
2 years
Yeah.
has changed.
Libraries have changed.
And libraries have changed. You're not checking out books anymore.
Exactly.
So all of that is taken into consideration on what's being designed. So when you pause, you take all those things into consideration and how you're going to redesign and make your structures, facilities applicable to the needs.
So moving on, here are a list of Laney's smaller projects, not capital major projects that I focused on the schedule. Once again, each campus are slightly varied, but also a lot of those projects are duplicated, like the elevators, like roofing replacements, building management systems, and projects similar to those. And you can review that on your own when I send this to you guys in PDF. The next item is Merritt College. We have the Child Development Center, the Horticultural Center, the Science Allied Health Building, which is a remodel, interior remodel or a completion of the Barbara Lee building, as well as phase 2 projects, which are the locker room gym, as well as the building B renovation. And for Merritt College, once again, there's a list of projects that are not capital projects, but they are considered major projects that have been listed. And of course, once again, the completion of those projects, the status are there, as well as the dollar amounts associated with those projects. So for the ending, all I wanted to share is a few pictures of the projects as we are today. Merritt College, they're building their structure. I mean, they've been focused on a lot of site utilities, foundations, and so forth. We have buildings, and if you guys have an opportunity or wish to see the sites, please, you know, contact us and we can set up that walkthrough with you guys. This is the CDC building. This is from the rooftop. As you can see, well, it was a beautiful day. Let's just put it that way. You can see the campuses from behind the college. Next is the College of Alameda Aviation Complex. It is a rendering. It's an existing building right here, which is Hangar B, and of course the new building, Hangar A. This is the Hangar A rendering, and we hope to get phase 1 out of DSA soon, so we can go ahead and bid that out and start construction there within this quarter. And of course, College Valley Alameda, the new Transportation Technology Center, or the Auto Diesel. I like that name better, but the NTTC project just doesn't come out naturally.
Keep it Auto Diesel.
It's Auto Diesel. They are getting that structure up and running. So this is a month ago. So hopefully you guys can see out there. And
well, we started using new technology transportation center because it's more than just
exactly.
Yeah.
It is.
You know, powered vehicles is a really important complex, part of that complex. Sorry, I'm getting pretty pedantic.
Okay. All right, and that is my presentation. If you have any questions for me, I'm more than willing to answer them.
This is not so related to the construction specifically,
Okay.
but I'm just curious with the state's, publicly known shortfall of about 32 billion right now, will that affect matching funds for projects like this? Or is that like a different pocket that they access and it's safeguarding them away from?
The matching funds that the district was awarded, it's ours. They can't take it back at this point in time in the sense of the projects that
We have not indicate. Should I repeat that? So at this point, we have not have any indication from the state that they are going to call back. But what they have taken a second look at is housing, student housing. That's what they're looking at in terms of their funding. So that's what's under the scope right now, not these projects. These projects have been in this line to get funding, as I said, for almost 10 years. So.
And if I could say, these are bond monies that the state is giving you, and when you hear about the operational shortfall.
It's different costs, different things.
Are we surpassing the September deadline?
Well, technically, the meeting adjourned when two of the members left at 7:15. So this is a open discussion at this point. So we're fine.
Okay, so.
We can't vote on it.
And therefore, yes, we're not going to be voting on anything, but the recording of the meeting, did that stop when they left or did? it
No,
stop?
yeah, I continued. I accidentally stopped the recording just a moment ago, but I restarted it.
Okay, I was wondering about that.
That was me. That was trying to stop Sharon's screen share, and I pressed the wrong button. Sorry.
Regarding what you just showed us, all of those schematics and charts, I'm quite impressed with those. I think that shows that you have a good control of the money and the progress. So, questions, but I do thank you.
Thank you.
Oh, I have a quick question about the, I don't know if you addressed this, Sharon, or even Vice Chancellor Smith, about the upcoming Berkeley City College project and seeing where it is with the GMP as well too. If you had an update on that also.
Yes, we're looking over the GMP. The district wants to make sure how it is cost out from Excel construction, matches up, and what their allocations, their contingencies. We just want to make sure that it's in the right place and everything can be explained and spoken for, and that there's not just an inflated budget. We want to make sure that we understand exactly what is intended to be spent on.
Oh, the details, and make sure everything is streamlined accordingly. Thank you.
So I think your question more so is it moving forward?
Yes, the timeline rather.
Looking to bring that back for discussion to the board in February.
Sounds great. Thank you.
Well, since we have passed the 7 mark, I suggest that we adjourn. If this presentation is done, it sounds like it's done.
Thanks.